Article 114, Treason. Any Filipino citizen who levies war against the Philippines or adheres to her enemies, giving them aid or comfort within the Philippines or elsewhere, shall be punished by reclusion perpetua to death, and shall pay a fine not to exceed 4 million pesos. In the case of Raurel versus Misa, GR number L409, January 30, 1947, treason is a breach of allegiance and can only be committed by a person who owes allegiance, either perpetual or temporary. A citizen owes an absolute and permanent allegiance to his government, allegiance being the obligation of fidelity and obedience to the government in return for the protection received. A foreigner owes temporary allegiance to the government of the place wherein he resides in return to the protection he receives. Such temporary allegiance continues during the period of his residence. If an alien, while residing in a foreign country, does an act which would amount to treason if committed by a citizen of that country, he will be held liable for treason. Therefore, both citizens and aliens can be liable for treason. Second paragraph of Article 114. No person shall be convicted of treason unless on the testimony of two witnesses at least to the same overt act, or on confession of the accused in open court. Likewise, an alien residing in the Philippines who commits acts of treason as defined in paragraph 1 of this article shall be punished by reclusion temporal to death and shall pay a fine not to exceed 4 million pesos. The two-witness rule requires a person shall not be convicted of treason unless on the testimony of two witnesses to the same overt act. If the overt act is separable, two witnesses must also testify to each part of the overt act for conviction. That is under People v. Adriano, GR L477, June 30, 1947, and People v. Abad, 78 Phil 766. It is not, however, required that the testimony of the two witnesses must be identical, although there may not be corroboration between the two prosecution witnesses on the points they testified, yet when the witnesses are uniform in their testimony on the overt act of treason charge, the two witnesses rule is complied with. People v. Concepcion. Thus, one witness might hear a gunshot, see a smoking gun in the hand of the accused, and see the victim fall. Another witness, who was deaf, might see the accused raise and pointed the gun and see a puff of smoke from it. The testimony of both would certainly be to the same overt act. From the Revised Penal Code by Justice Luis Reyes. Two-witness rule is not applicable in proving crime other than treason, such as conspiracy or proposal to commit treason, misprision of treason, or conspiracy to commit rebellion, lifted from 2018 bar exam. The accused may also be convicted upon his confession in open court. Two-witness rule is not applicable if there is a judicial confession. On the other hand, extrajudicial confession is not enough to convict the accused for treason. Alarcon, GR number L407. At least two witnesses must still testify on the overt act of treason as a precondition for his conviction. Article 115. Conspiracy and proposal to commit treason. Penalty. The conspiracy or proposal to commit the crime of treason shall be punished respectively by prison mayor and a fine not exceeding 2 million pesos, and prison correctional and a fine not exceeding 1 million pesos, as amended by RA 10951, August 29, 2017. In a nutshell, proposal or conspiracy to commit treason is committed by a Filipino citizen or resident alien who has decided to commit treason and proposes its execution to some other person or persons, while conspiracy to commit treason is committed by two or more Filipino citizens and or resident aliens who come to an agreement concerning the commission of treason and decide to commit it. Under the doctrine of absorption, proposal, if a person to whom the proposal is made does not agree to commit treason, the proponent shall be held liable for a crime of proposal to commit treason. If a person to whom the proposal is made agrees and decides to commit treason, said person and the proponent shall be held liable for the crime of conspiracy to commit treason. The proponent cannot be separately held liable for proposal to commit treason, since conspiracy to commit treason absorbs proposal to commit treason. If the person to whom the proposal is made actually commits the crime of treason, said person and the proponent are conspirators and are liable for the crime of treason. The proponent is also considered as principal by inducement. The conspirators could not be separately held liable for conspiracy to commit treason, since treason absorbs the crime of conspiracy to commit treason. Conspiracy in this case is just a mode of committing treason for purposes of applying the collective responsibility rule. And to be held liable for conspiracy to commit treason, the offenders must be in the position to commit treason, since treason can only be committed by Filipino citizen and resident alien. The offenders in conspiracy to commit treason must likewise be Filipino citizen and resident alien. According to C.A. Justice Luis Reyes, conspiracy or proposal to commit treason is committed in time of war. However, according to Justice Florence Regalado, the crime of proposal or conspiracy to commit treason or misprision of treason can be committed in peacetime, although they are more often wartime offenses. If offenders conspire to levy war against the Philippine government in adherence to its enemy, the plotters are liable for the crime of conspiracy to commit treason, even though the conspiracy was hatched in peacetime. Group of armed men seized the southern island of the Philippines and declared war against the government. X, a Filipino, and Y, a citizen of Rwanda, agreed to help the armed men by raising funds in support of their armed struggle. X and Y are not liable for conspiracy to commit treason for the following reasons. Number 1. The armed men who seized a southern island of the Philippines are liable for rebellion by rising publicly and taking up arms to remove a southern island of the Philippines from the allegiance to the government and its laws. Lagman Medeldia, GR 231658. Thus, agreeing and deciding to help the rebels by raising funds constitutes conspiracy to commit rebellion and not conspiracy to commit treason. Number 2. Treason and conspiracy to commit treason are war crimes. They cannot be committed in times of peace. The war contemplated in treason and conspiracy to commit treason pertains to armed dispute between the Philippines and a foreign state, and not a mere civil war. Since the Philippines is not at war with a foreign state, X and Y cannot be held liable for conspiracy to commit treason. Number 3. Y, for not being a Filipino citizen or a resident alien, cannot commit treason. Hence, Y cannot conspire with X in committing treason. Article 116. Misprision of treason. Every person owing allegiance to, open and close parenthesis, the United States, the government of the Philippine Islands, without being a foreigner, and having knowledge of any conspiracy against them, conceals or does not disclose and make known the same as soon as possible to the governor or fiscal of the province, or the mayor or fiscal of the city in which he resides, as the case may be, shall be punished as an accessory to the crime of treason. Misprision of treason is the failure of a citizen to report as soon as possible a conspiracy against the government. The offender is punished as an accessory to treason, but there must be a war in which the Philippines is a party. Conspiracy to overthrow the government when there is no war is rebellion, and misprision of rebellion is not punishable. A person who fails to report a conspiracy to overthrow the government during peacetime is not criminally liable for misprision of treason, for this is committed only during wartime. Misprision of rebellion, coup d'etat, or sedition is not punishable too. Failure of a priest to disclose information given by confessant pertaining to conspiracy to commit rebellion is not punishable. Misprision of rebellion is not a crime punishable under the Book of Statutes. Nullum crimen nulla pena sine lege. Moreover, his non-disclosure of such information is due to insuperable cause, which is an exempting circumstance, since confession is confidential, and he has an obligation to the Church not to reveal the same. Lifted from 1994 bar exam. Treason and conspiracy of proposal to commit treason can be committed by a Filipino citizen and a resident alien, from 2018 bar exam, while misprision of treason can only be committed by a Filipino citizen. A resident alien cannot commit misprision of treason. For example, A, a Filipino citizen, and B, a resident alien, were present when X, a Filipino citizen, and Z, a resident alien, conspired to commit treason. However, A and B did not disclose the information regarding such conspiracy to proper authorities. X and Z are liable for conspiracy to commit treason. A is liable for misprision of treason. B, for not being a Filipino citizen, is not liable for misprision of treason. In misprision of treason, a Filipino citizen obtains knowledge of conspiracy to commit treason by a Filipino citizen or resident alien, but he fails to report the matters to proper authorities. 1955 bar exam. During the Japanese occupation, one could not commit misprision of treason since there are no authorities to whom information on conspiracy to commit treason could be reported to. Misprision of treason cannot be committed without conspiracy to commit treason. Thus, failure to disclose information regarding the location of the food, supplies, and arms of the enemy is not misprision of treason. If a Filipino citizen obtains knowledge of the crime of treason, failure to report the matter to proper authorities is not misprision of treason. Misprision of treason is failure to report conspiracy to commit treason and not failure to report the crime of treason. Another example, while the Philippines is in a state of war against China, A Filipino citizen, obtained knowledge of a correspondence between B, a Chinese general, and C, an Italian citizen, who is a resident of the Philippines, where the latter agreed to provide vital information on the military defense of the Philippines to the Chinese government. However, A did not immediately report the matter to the proper authorities. A is not liable for misprision of treason. B cannot commit treason since he is a Chinese citizen who is not residing in the Philippines. Since B cannot commit treason, he cannot conspire with C to commit treason. Since there is no conspiracy to commit treason, A cannot be held liable for misprision of treason. Providing military information to the enemy is treason by adherence to the enemy by giving aid and comfort. However, failure to report to authorities the intention of C to commit treason is not misprision of treason. From 2010 for exam.